Welcome and thank you for joining us today for our webinar on international arbitration in the US and the Americas. My name is Sandra Friedrich. I'm a lecturer in law here at the University of Miami School of Law, and I'm also the director of Miami Law's International Arbitration Institute and White & Case International Arbitration LLM program. It's my pleasure to be your moderator for today. This webinar series is jointly organized by the University of Miami School of Law, the Miami International Arbitration Society, the Japan Commercial Arbitration Association, and the Japan International Dispute Resolution Center. I think we have some very interesting discussions lined up for you today, and there also will be plenty of opportunities to ask questions through the Q&A function that you have at the bottom of your screen. Feel free to submit your questions throughout the webinar, and we will address them in the Q&A session after section 1. Before we start, I also would like to invite all of you to join the second session of this webinar series, which will happen next Friday, April 30th, and which will focus on Japan touchpoints in the Americas and will include discussions on the economy, on international arbitration and alternative dispute resolution, and on developing capacity in this field. Our wonderful program coordinator, Arlene Buchanan, under the handle of White & Case International Arbitration LLM, will be sharing a link in the chat for you right now, where you can learn more about the second session and also sign up for that. And now, without further ado, we will hear opening remarks, and I would like to hand over the virtual microphone to Adolfo Jimenez, who is a partner and litigator with Holland & Knight here in Miami, and who also serves as the chairman of the Miami International Arbitration Society, which is one of the co-organizing entities of today's webinar. Adolfo, the floor is yours.
Thank you, Sandra. And again, I'd like to welcome everyone to this program. The Miami International Arbitration Society is dedicated to bringing practitioners together to promote Miami as a seat of arbitration, to gain understanding and gain knowledge between different jurisdictions. And it's an honor to be able to connect with our colleagues in Japan. We very much appreciate this opportunity and to be able to present today. Miami is a special city. Obviously, it's not just our home. We consider it much more than that. It's a burgeoning international arbitration location. And so it's an area that we very much care about. And the Miami International Arbitration Society is dedicated to promoting our position. Miami is also not just a gateway, but an academic institution hub with a lot of different academic institutions. And today we're very fortunate to have the University of Miami School of Law that's doing so much to promote the practice of international arbitration. We're very proud to be able to collaborate with you. And I'm very excited to be able to participate in today's program and to hear today's excellent panelists. Thank you.
Thank you very much, Adolfo. And with that, it is my pleasure to hand it over now to Dean Caroline Bradley for a brief welcome. Dean Bradley is a professor of law and a Dean's Distinguished Scholar here at the University of Miami School of Law, which is one of the co-organizers of this event. She also serves as Associate Dean for International and Graduate Law Programs at the law school. Dean Bradley, please.
Thank you so much, Sandra, and thank you, Adolfo. At the University of Miami, we have a long history of engagement with international and comparative law, and we have many more faculty with interests in international law than most US law schools do, including Rick Williamson, who has been a longtime colleague of mine and who's speaking on the panel today. The White & Case International Arbitration Program is an important component of our graduate programs, and Dan Gonzalez, also on the panel today, is a valued professor in that program. I'm very much looking forward to hearing from all of the panelists today. Welcome to the panelists and also to you, our audience. I'm very happy to be here. As Adolfo said, I also am happy to welcome you on behalf of the University of Miami School of Law to the first in this series of 2 webinars on international arbitration in Japan, the US, and the Americas, which we're organizing together with MIAS. We're happy to collaborate with you and hope to be doing more of this in future, and also with the Japan Commercial Arbitration Center Association and the Japan International Dispute Resolution Center. Cooperation is so important in the world that we're living in right now, and we can learn valuable lessons from one another when we work together. Thank you. I'm going to hand it back to Sandra now.
Thank you very much, Dean Bradley. And now we'll have a few welcoming remarks from Yoshihisa Hayakawa, who is the Secretary General of the Japan International Dispute Resolution Center in Tokyo, which is also one of the co-organizers of today's program. Mr. Hayakawa.
Thank you very much, Sandra. And it is our great pleasure and honor to host this very interesting event with Miami University and other related organizations in Miami. And Japan International Dispute Resolution Center, JDRC, we call it. And the JDRC is a not arbitration institution. And we are newly established by the government and with $8 million US budget to encourage the use of international arbitration for Japanese business organization. Until recently, unfortunately, the use of international arbitration is not so well used by the Japanese international business corporations strategically. And because there are so many reasons historically or cultural background or something like that. And I will explain these issues in the second session 1 week later. But anyway, we are going to change, and the Japanese government have a very strong policy to change the situation. And with the $8 million US budget, and using the budget, we are promoting international arbitration in Japan. We are providing the brand new gorgeous facility for the hearing for the international arbitration here in Japan, Tokyo, and Osaka. And we are providing the, so many events for the business corporations to know about the arbitration or to how to use strategically the international arbitration. And we will provide training courses, education courses for the younger generation, especially in Japan. And we are doing the PR activity for foreign related peoples. So this event is one of our programs, and especially for the education and human resource trainings. So I personally looking forward to hearing today's discussion from now on. Thank you very much, Sandra.
Thank you very much for this very warm welcome. We'll now start with our first discussion session, which will provide an overview on international arbitration in the US and the Americas. And it is my pleasure to introduce to you our 4 distinguished panelists for this first part of the webinar. We have Matthew Drosos, who is a partner in White & Case's international arbitration and litigation practice in Washington, D.C., where he represents clients, both corporations and sovereign states, on matters before the International Center for Settlement of Investment Disputes, also known as ICSID, the Geneva Chamber of Commerce, the Court of Arbitration for Sports, the International Chamber of Commerce, also known as the ICC, as well as US federal courts. His representative matters have included disputes involving metals and mining, construction, textiles, and sovereign financing instruments. We also have with us today Daniel Gonzalez, who is a senior partner in the disputes practice at Hogan Lovells right here in Miami. Dan dedicates his practice to international commercial litigation and arbitration, and he represents clients and sovereigns in major bet the company type disputes in the United States, in Canada, and across Latin America, Asia, and Europe. Dan's practice focuses on disputes involving construction and infrastructure, as well as energy, mining, financial services, securities, and telecommunications. And Dan, of course, as Dean Bradley has mentioned, also serves as an adjunct professor in Miami Law's White & Case International Arbitration LLM program, where he teaches a course on forensics of advocacy in international arbitration. And he also oversees and works with our students through the Practicum program. Third, we have on our panel, Catherine Menendez de la Cuesta, who is a partner and litigator in Hollins & Knight's Miami office, where she handles international disputes. Representative matters have included international arbitration and court proceedings arising out of mergers and acquisitions, energy, transportation matters, including airport, mining, and rail industries. Catherine has handled cases applying a variety of domestic, state, and national laws and before major arbitral institutions across the world. And last but not least, we have Professor Richard L. Williamson, Jr., who is a professor of law emeritus at the University of Miami School of Law, where he has taught introductory and advanced courses in environmental law, alternative dispute resolution, and courses and seminars on international law topics such as public international law, arms control, and international environmental law. Prior to coming to Miami Law, Professor Williamson served as a Foreign Services Officer in the U.S. Department of State, as a counselor and executive director of the American Foreign Services Association, and as a division chief of the U.S. Arms Control and Disarmament Agency. He also worked as an attorney with the law firm of Cleary, Steen, Gottlieb, and Hamilton. As we have a large audience here with us today from Japan, I also wanted to mention that Professor Williamson spent 2 years in Japan in the Air Force when he was stationed in Misawa. And he also has lectured and published an article at Osaka University on the role of government in ADR in the United States. Professor Williamson will be starting us off with an introduction to the U.S. legal system and framework for international arbitration in the U.S. and the Americas. Professor Williamson, go ahead, please.
So I'm going to be discussing today the legal system in the United States and how that legal system impacts on arbitration. And then a very, very short overview on the rest of the countries of the Western Hemisphere. And finally, a very short story about red wine. The pictures that you see are of key buildings in Washington, D.C., but as pleasant as a picture of the Capitol and Japanese gift of cherry blossoms. We're more interested in the substance, and the United States had been a colony of Great Britain, and that experience left the United States, the people of the United States, with a great fear of governmental power. And the result of it was that our first attempt at a constitution was a weak confederation, and it was a failure. The solution that was picked was to have a constitution providing a much more powerful central government, but protected from governmental abuse by three things. First, a strong preservation of individual rights. Second, a separation of powers. And a third, federalism. The Constitution's individual rights provisions were very few in the first draft, but in order to get the Constitution ratified by the states, it was necessary to add 10 amendments, which includes famous ones like the freedoms of religion, press, speech, etc., rights of fair trials, and the rights of states, which could not be violated by the new federal government. Most of these were applied also to the states in the subsequent years. The original constitutional draft did have a few protective provisions, and the one that's important for arbitration is that no state may pass a law which interferes with the obligation of contracts. And that's been subsequently applied also to the federal government, and what constitutes a law for these purposes was also broad. And that takes us to Baron Montesquieu. Montesquieu was a winemaker, and indeed, if you enjoy red wine, and especially if you enjoy Cabernet Sauvignon, you'll be interested to know that he actually was the first person to create that wine by genetically crossing two existing wines. He was also a famous lawyer and judge, but we're primarily interested in him because he's also a famous political philosopher, and he was the first person to speak up about the great importance of the separation of powers. And he favored a complete separation of the legislative, executive, and judicial functions of government. So the chart here shows Montesquieu's ideas about how government should be organized, and that's not exactly what happened under our Constitution. because we decided that some overlap was necessary to have these three branches have some influence over each other. Most of the listed powers in the Constitution are granted to the Congress as our legislature. When it comes to arbitration, Congress has a power to adopt legislation, and it did so in the Federal Arbitration Act in 1925, reversing a long period of time when the courts of the United States were very hostile to arbitration, or for that matter, anything else that deprived them of their jurisdiction. Since then, there's not been much legislation, but the Congress also has, especially the Senate, a vital role in approving treaties involving arbitration and any implementing legislation. The executive powers under the Constitution are vested in the president, whose task, among other things, was seeing the faithful enforcement of the laws. But the president and the executive branch generally have not had a major role concerning arbitration, with some domestic exceptions dealing with, for example, labor management disputes, some consumer matters, and cases where the government itself is a party to it. The judicial branch is headed by a Supreme Court, and that court takes cases only when it feels it merits its attention. The Supreme Court has ruled on many arbitration issues, virtually always in the process strengthening arbitration. And in addition to the Supreme Court, there is a system of lower courts. Unsuccessful litigants may bring a case to the relevant appeals court as a matter of right. But unlike some other countries, such cases are nearly always decided on legal grounds and not on a relitigation of the facts. The states of the United States, this map shows 48 of them, of our 50. The United States is a federation. Legal authority is split between the national government and the 50 states. Each state has its own constitution, body of laws, a legislature, a governor, who's the chief executive, administrative agencies, and multi-level courts. In many areas, the federal government is the dominant one, but the states in many other areas actually have bigger roles than the federal government, including substantive contract law. The Constitution does have a supremacy clause, which makes the laws of the United States superior to any contrary state law. And the consequence of that for arbitration is that the law governing arbitration is entirely federal. The states have no role in the arbitration matters per se, unless the federal legislation doesn't deal with the matter, and that sometimes happens. As already noted, the substantive law of a contract will almost always be state law. The countries of the Western Hemisphere, which speak either Spanish or Portuguese, are shown on this map. The non-Latin American countries, which other than the U.S., that is to say Canada and the Caribbean, many of the Caribbean states, use a parliamentary system of government rather than a presidential one, and utilize common law. The Latin American democracies utilize the presidential government or some modification of it, and some of their constitutions extend to the president the right to rule by decree. Though there are many similarities, each government has its own body of legislation. Like the U.S., Latin American courts were initially quite hostile to arbitration, and that was especially true for international cases. And that remained generally true long after the U.S. had shifted to a pro-arbitration policy. However, after World War II, that began to change. The last holdout was Brazil, which is now actually one of the leading countries in Latin America for arbitration. Now, all of the largest Latin American countries and most of the smaller ones have favorable arbitration legislation. All of them are parties to the New York Convention or the Panama Convention or both, and some have adopted the ICSID Convention. Despite all that, many times international cases involving parties in Latin America actually take place in the US, with the leading places for that to happen being New York or Miami. Finally, a warning. Just because Latin American countries are presidential and utilize civil law, that they have become parties to the same or related treaties, that they have somewhat similar arbitration laws, does not mean you can assume that they are the same. Each must be investigated in its own right. Thank you.
Thank you very much, Professor Williamson. I want to turn to our panel and see if one of our other panelists would like to briefly comment on Professor Williamson's presentation before we move on to the next topic.
Thank you, Sandra. I may add, thank you, Professor Williamson, for your wonderful presentation. I just would like to add that in line with what Professor Williamson said, in the US, there is a pro-arbitration policy, and the United States has confirmed that policy in several cases. And that means many things, but one of them is that when arbitration agreements have been interpreted, most of times they are interpreted in pro of arbitration. So if there is a question about, for instance, the scope of the arbitration agreement, it is usually, courts are usually instructed to interpret that arbitration agreement pro arbitration.
Thank you, Catherine. And I'm going to stay right with you since you will be explaining to us and our audience today how U.S. courts have applied the doctrines of separability and competence.
No, thank you. And well, first of all, it is a pleasure to be here. Thank you so much for being with us today. And today I will address the question that you're seeing right now, and it is about two doctrines that are very important in international arbitration: the doctrine of separability and the principle of competence, and in particular, how U.S. courts interpret and apply these two very important principles in international arbitration. And I would like to start with an introductory idea that we touched a little bit upon before with Professor Williamson, and that is that in the United States, arbitration is a matter of consent. And why that is important? Well, it is important because in the US, courts will enforce arbitration agreements according to their terms. And what this means is that courts will pay a lot of attention to how the parties drafted the arbitration agreement, what they said, what they did not say, and how they said it. Because courts will enforce arbitration agreements according to their terms, parties enjoy an extraordinary latitude in structuring their arbitration agreements. And so it is very important that they are aware of the consequences, not only generally to agree the consequence of agreeing to arbitration, but also the consequences of adding these terms or not adding them. What is the doctrine of separability? Well, we know that this doctrine, what it says is that arbitration agreements can be separable from the contracts in which they are included. And what is the purpose of this doctrine? The best way to think about this, I think it is to imagine the doctrine didn't exist. And that would be if we treat the arbitration agreement together with a contract, so that if the contract as a whole is considered valid or invalid, that determination also applies to the arbitration agreement or the arbitration clause. And so if we have, for instance, an arbitrator deciding that the whole contract is not valid, then he would be also determining that the arbitration agreement is not valid. And that arbitration agreement, it was what gives the arbitrator the authority to make that determination. If a court decides that the contract as a whole is valid, and so the arbitration agreement is also valid, didn't the parties want, because of that arbitration agreement, that determination be made by an arbitrator and not the court? So to address this conundrum, we have the doctrine of separability. And when it says essentially is that attacks to the validity of the contract will not necessarily prevent the arbitration from going forward. What is the doctrine of competence? This doctrine says that the arbitral tribunal has authority to decide its own jurisdiction. And what this means is if an arbitrator's authority is challenged by one of the parties, does the arbitrator need to stop the arbitration and wait until a court determines whether the arbitrator has authority or not to proceed? The answer to this question is provided by this principle of competence, and the answer is no, because an arbitrator has authority to decide its own jurisdiction. Arbitrator may make the determination and the arbitration may proceed. An important issue of arbitration law is whether this positive effect of the doctrine, which means the arbitrator has the authority, and that's the positive effect of it, also has a negative effect, which means that because the arbitrator has the authority, then courts are taking that authority away. In other words, that the authority is exclusively for the arbitrators after the parties agree to arbitrate. And a key point is that in the US, this negative effect doesn't exist unless the parties agree otherwise. And this is, for instance, the difference with France, where the principle of competence has been interpreted to have two effects, also negative. And so courts do not have jurisdiction to decide the arbitrator's authority when arbitrators have that pursuant to this doctrine. In the US, courts will retain that jurisdiction unless parties agree differently. You will see when we advance a little bit further on these two principles, how in the US, the question really is about who decides. We will see how these principles have shaped several of the answers to this specific question. And so I will spend just a minute on it. Why is it important? Well, it is important for several reasons. Think if you have an arbitration agreement and opposing party doesn't respect it and initiates litigation in the US, and that party says that the arbitration agreement is invalid for whatever reason, or that the dispute should not be arbitrated because the parties agreed to negotiate first and they didn't do that, or because the claim is time barred, or because the dispute falls outside the scope of the arbitration agreement, or because the contract was never formed. All these challenges, and if we have an opposing party going to a court initiating litigation, if the issue that party is raising is under US law for the court to decide, we will probably need to litigate that issue in front of the court. But if it's for the arbitrator to decide, then we can ask the court to compel the party to arbitration and to restrain from deciding that issue. Further on in the arbitration, if we need a court to support the arbitration by issuing, for instance, interim relief, or if we already have an award and we need a court to enforce that award or to vacate that award in the US, if the issues that parties raise challenging the arbitration award or the arbitration agreement are under US law for either the arbitrator or the court to decide, the level of deference of the court to the arbitrator's decision or the level of review that the court will make will depend and will be different. Now, focusing on separability under US law. We said that separability is essentially the doctrine that says that arbitration agreements are treated separable or are treated separately from the contract as a whole. And what the law says and what the United States has held in different cases is that if a party attacks the validity of the contract as a whole, not the validity of the arbitration agreement, but the validity of the contract as a whole, then the separability doctrine applies. The arbitrator retains his or her jurisdiction to decide the issue, and it will be for the arbitrator to decide. In other words, the arbitrator will decide whether or not that contract is valid, because thanks to this separability doctrine, the authority of the arbitrator is preserved. Now, if a party attacks not the validity of the contract as a whole, but the validity of specifically the arbitration agreement, that's different. And then because that goes into the basis, the most fundamental question in arbitration about whether parties really agree to arbitrate or not, because they are attacking the arbitration agreement, their agreement to arbitrate, then parties have an opportunity to have that question decided by the courts, unless parties decide otherwise. And I added at the end of the slide, importantly, the issue of whether the contract was ever formed is different from the validity of the contract. And that issue, even if it's an attack on the contract as a whole, if it is about whether the contract was ever formed, that's still for the court to decide. And then competence under US law. Well, we said that competence is about the arbitrator's authority to decide his or her own jurisdiction. And here in the US, we call this principle oftentimes the arbitrability question. And what we mean by that is, did the parties agree to arbitrate this dispute now? And the reason why we formulate it this way is because the question of arbitrability has all these components. As you can imagine, parties sometimes challenge the first one, the parties, these parties and not other parties, or whether there is agreement, whether there is consent to arbitrate, or whether this dispute is covered. So we would be talking about the scope of the arbitration agreement. Parties may have agreed to arbitrate some disputes, but not some others. And because in the US, arbitration is a matter of consent, if a party has only agreed to arbitrate a specific dispute, that the party will not be forced to arbitrate other disputes. And finally, now, sometimes it's a matter of timing. Sometimes we are saying, well, parties agreed to mediate before they arbitrate, or there are some notice requirements that a party did not meet. So it is too late because the claim is time barred. All these questions have been divided by US courts into two groups, what we call gateway questions or substantive arbitrability issues. This group deals with consent. So did the parties agree to arbitrate? Is there consent? Issues about scope, this particular dispute. Is this issues about non-signatory? Can this arbitration clause extend to non-signatories? That's the first group. And then we have the second group. And this group deals with timing, with conditions. And what the Supreme Court has said is that the first group is generally for the court to decide. Why? Because they deal with very important questions. They deal with the parties' consent to arbitrate, whether the parties consented to arbitrate this dispute. If it is about timing or about other conditions, well, in those cases, it is clear that the parties consented to arbitration, but they disagree as to whether the time is too early or too late. Those questions are for the arbitrators to decide. And finally, delegation clauses. The first group, I said, for the court to decide, but I added there, except if delegation. What this means is that in the US, parties can make agreements. I said at the beginning, arbitration is a matter of consent. Parties may say, okay, even if this is a gateway issue, even if it's substantive arbitrability, we agree it will be for an arbitrator to decide. When does this agreement happen? When it is clear and unmistakable that parties agreed so, that parties decided that the issue so important will be for an arbitrator to decide. Finally, is reference to a set of arbitral rules in the arbitration agreement, clear and unmistakable evidence. We all know that in arbitration agreements, usually parties agree to arbitrate under a set of rules. Those rules sometimes include the issue that arbitrators will have authority to decide. Well, in the US, many courts have decided that's enough to have clear and unmistakable evidence. And what that means is that many issues related to consent, not whether the arbitration agreement was ever formed. That's too important. But everything else, scope, validity, all those issues are for the arbitrator to decide if the parties agreed so. Thank you very much. And that's it.
Thank you very much, Catherine. And I believe one of our other panelists, Matt Drosos, would like to also comment briefly on the topic of competence, and separability. Matt, go ahead.
Yeah, no, thank you, Sandra and Catherine, for the good presentation. I think one thing for the panelists to remember and keep in mind that these are questions that come up all of the time. And, this is not something that is just rarely argued, but a lot of the times, depending on what's going on in the arbitration, there will be challenges as to whether the entire contract is valid, whether the agreement to arbitrate is valid. And so one of the things to think about as working in a firm or advising your clients is also to look pre-dispute, but think about it when you're forming contracts as to the language of the disputes clause, when you're choosing the law of the seat, because as Catherine mentioned in her presentation, different jurisdictions deal with this in a very different way. So the United States courts have dealt with issues like competence differently than, say, French courts, and they will have dealt with it differently than German courts or the Swedish courts or British courts. So keep in mind as you're looking at one, either assisting with a contract where the seat of the arbitration is and where this may be, what law this may come under later on. And then also when you're brought in for disputes purposes, take a look at that and then look at the underlying law and then consider how you want to advise your client on whether it's useful for them to challenge or whether they need to be careful of these issues as they go forward in the dispute. So it's still a very live issue in a lot of cases.
Thank you, Matt. Before we move to the next presentation, I also want to remind our attendees that you can submit questions for the Q&A that we're going to have in a little bit through the Q&A function at the bottom of your screen. So please go ahead and put your questions there and we will answer them in a little bit. And with that, I'm actually going to go back to Matt, who will explain to us today the scope of disclosure that foreign parties should expect in an international arbitration proceeding in the US or the Americas more broadly, or in arbitrations that involve American parties. And Matt also will explain the special disclosure mechanism under Section 1782 and how it may apply to commercial arbitration proceedings that are seated outside of the United States. Matt, go ahead.
Thank you, Sandra. Let me hope everybody can see the slides okay. And it's as you can tell, it's a very broad topic. I am going to just spend about a minute or two talking about production generally. The first part of the question, while it sounds broad, international arbitrations, oftentimes, even if they're seated in the United States, Professor Williamson was saying, many of the arbitrations that are conducted out of Latin America may be seated in New York or in Miami. I'm involved in one in Miami, but then also they may have other varying seats throughout Latin America. Oftentimes, and you see this more and more in arbitrations, the tribunal and the parties have agreed to be guided by the IBA rules on the taking of evidence in international arbitration. And over the course of many years, this document has been prepared by practitioners, it's been informed by practitioner, and it's been revised over the years. And so oftentimes you will see a lot of reliance on this and a lot of argument during document production and document requests referencing the standards in here. And I put up two of the articles on the screen that are primarily referenced when doing document production, IBA Rule Article 3 and IBA Rule Article 9. And Article 3 is the one that you largely point to when you're formulating your requests and the requirements that you need to articulate in order to hopefully get the tribunal to grant your request. And they are related to the way the standards under U.S. courts, although many view them as slightly more narrow, and tribunals being more reticent to grant as broad a discovery as they may grant under U.S. discovery and disclosure rules. But Article 3, you see, you need to be able to identify and describe with a narrow and specific definitions a requested category of documents. Those documents have to be shown to be relevant and material to the outcome of the case. And they also have to be in the possession, custody, control of the, or shown to not be in the possession, custody, and control of the requesting party, and that they should be in the possession, custody, and control of the party to which the request is directed. IBA Rules Article 9 are some of the bases for the objections that you can articulate. That effectively they're the flip side of what you have to define when you're making the request, that the documents that are being sought are lack sufficient relevance or materiality. You can raise issues of legal impediment and privilege. If a document is privileged, you don't have to produce it, and that is almost universally recognized across all jurisdictions. Or that the requested material is unreasonable. It would provide an unreasonable burden to produce because the request is overly vague or burdensome. And so if it's not narrowly tailored, then the request could be rejected. But what I would like to do and spend most of the time on this is the second part of the topic, and it's this. It is this provision in the United States Code that's called Section 1782, and you will often hear this in the legal news or in articles as 1782 proceedings, and it's a fairly interesting provision in the U.S. Code, and I've pulled out the relevant language of it here on the slide. And it's where you can, as a party in an international arbitration, you can request that the district court of the district in which a person is found, the court may order him to give his testimony or statement or to produce a document or other thing for use in a proceeding in a foreign or international tribunal. So this language right here has been the subject of a significant amount of court battles and debate because what it can do is provide parties to an international arbitration, in an international foreign proceeding or international tribunal, the ability to go to U.S. courts to seek testimony from an individual or seek the production of documents from companies or individuals that may relate to your dispute, even though those companies or individuals are not involved in the dispute, are not part of the parties to the dispute. It provides a good tool if you can meet the requirements to gain additional evidence to support your arguments. Now, the issues that arise with respect to 1782 is that you have to meet the statutory requirements, and then how these statutory requirements have been interpreted over the years has changed, and there's been the subject of many court battles, and is currently the subject of a circuit court split in the United States. The appeals courts to which the federal court's decisions can be appealed have split on this issue. And as I'll talk about towards the tail end, this is a live issue currently before the Supreme Court in its term right now. So the statutory requirements that you have to show are effectively that the court you go to is the district in which the person resides. And so the person lives there, the company that you're seeking documents from is headquartered there, has a significant operation there. Sometimes, as you can see in one of these points, courts allow you to tag an individual if they just simply are traveling through that jurisdiction. You can still serve them with a subpoena to either provide testimony or documents. But usually what you do is you're identifying where companies are headquartered and going to the district court there and then requesting a subpoena. The second statutory requirement is that the discovery must be for use in the proceeding for a foreign or international tribunal. And it's here where a lot of the interpretation and debate has arisen, because what exactly is a foreign or international tribunal? And more specifically, whether it applies to international commercial arbitrations or only international tribunals that are formed under foreign law or that are government or in some way not commercial. I point out one of the key cases that is currently standing from the U.S. Supreme Court, Intel Corp v. AMD, which applied to the categories of documents, but then also said that it doesn't apply to, or it was unclear on whether it applied to international commercial arbitrations or only international arbitrations under foreign law, such as ICSID arbitrations and UNCITRAL arbitrations initiated under treaties. I'm going to go quickly through this slide because all it is simply saying that you can do this early in the proceeding. Once a case has been started, it's an ex parte application to the district court. There's no need to first bring in the other side. You're applying to the district court to get a subpoena ex parte, which means that the other side doesn't have the ability to immediately respond to it. And as long as you satisfy the statutory requirements, you could get a subpoena for the production of documents or testimony. Once you seek discovery, or once the party is advised of this, they can challenge it, and other interested parties can intervene, and they have in the past, if they feel that they are, one, involved, and two, have an interest in the matter. But you can start the proceeding completely ex parte. This is a list of some of the cases that are they have given rise to the current circuit split, which is what can qualify as a foreign arbitral tribunal. And you can see that, for example, the Second Circuit has said that this is only defined as a state-constituted tribunal pursuant to a treaty or other international agreement. So this would be an ICSID matter, an UNCITRAL matter. It could be one of the other ones if it's established pursuant to a treaty. And then others, including the 11th Circuit, have recognized that it does include private arbitral institutions such as the ICC. So this is by no means an exhaustive list here, but these are some examples of, on the left, you can see some of the institutions that run international tribunals that are formed under treaties and are often the secretariats that help manage the arbitrations. ICSID through the World Bank. UNCITRAL is applied in several ad hoc arbitrations, the Permanent Court of Arbitration. And to the right, you see some of the institutions that run primarily commercial arbitrations. The ICC is by far the biggest and has the most of all of these, but the others are all significant ones as well, including the LCIA based out of London, SIAC based out of Singapore, the ICDR, which is the US under the US version. And here I've listed the Chartered Institute of Arbitrators. And I mention them here because this is the subject which is currently at issue before the Supreme Court. The case that I'm speaking about is titled Servotronics Inc. v. Rolls-Royce PLC. And this is a matter, and this is just a little bit of background to the case, but it's a case where there was a faulty engine, and during a test run, there was an explosion. And it was during a Boeing test run, and it was a Rolls-Royce engine, so provided by the Rolls-Royce company. Those two got into a dispute, but there was ultimately a settlement between them, and there's no ongoing litigation. What happened subsequent to that settlement was that Rolls-Royce then brought an indemnification action against Servotronics, which provided the actual valve that was determined to have caused the explosion, for indemnification of what they had to pay in the settlement. And that is where the arbitration is going on in London between these two companies. Servotronics has sought production in the United States, and it's here where they've utilized 1782 to try to obtain the testimony of Boeing engineers and Boeing individuals involved during the test of the explosion. Rolls-Royce has opposed it, so has Boeing, and it's given rise to two different decisions in two different circuits that have highlighted the split. And the US Supreme Court has accepted certiorari, and they're going to be addressing this issue during the current term. And here, this is some of the potential outcomes. Now, trying to read the tea leaves of what the US Supreme Court is going to do is very difficult. But one, the US Supreme Court could find that, yes, this 1782 action does in fact encompass commercial arbitrations, including those under the ICC rules or LCIA that are purely contractual. It could reject that and follow the line of circuit courts which say no, only those established under treaties or international law are recognized as valid and satisfy the requirements of 1782, or it could potentially take another route, which is less clear. And so it's really going to be an interesting one that's going to be watched by many practitioners, both in the international civil litigation field as well as the international arbitration field, in terms of what you can use and how you can use it. And lastly, I'm only going to say 10 seconds on this. It's an interesting thing that I came across in a recent case, is a provision under Japanese law that I found to be similar to 1782, where you can, as a barred attorney in Japan, issue a request through the Japanese Bar Association to get documents from companies. Sometimes it's utilized, sometimes it's successful, but while doing research for this particular case, the parallels were certainly interesting. And if anybody here has thoughts who's on the panel, would love to hear more about that as well. So with that, I will conclude my presentation. So thank you very much.
Thank you very much, Dan. I'm sorry, Matt. Thank you very much, Matt. It is late here. I apologize. I believe one of our other panelists, Dan Gonzalez, would like to comment on the issue of document production and disclosure and 1782 as well. Dan, go ahead.
Well, thanks, Sandra. I think I'll limit myself to just, Matt did a great job of giving us the overview. I think I would just want to say, in terms of 1782, and as he laid out very correctly, it is very much in play right now as to the exact application it will have to international arbitration. But needless to say, that if it does apply in the different scenarios that Matt outlined, it's a game changer, because international arbitration in the Americas, in the US, like many other parts of the world, the arbitrators are pretty limited as to the powers they really have outside of the parties that are in front of them to really compel production, to compel third parties to attend for testimony, for depositions, for production of documents. So the use of 1782 as a tool, which is why it became so popular in international arbitration within the circuits that have allowed it, is because it is a tool that allows you to go straight to the court and seek that information. And when I say it's a game changer on both sides. Because it's a game changer for those who want to seek that information, but also for those who perhaps, unbeknownst to themselves, they may be involved in an international dispute in some other part of the world, as is the case that are currently pending in London, and yet find themselves enthralled into a US-style discovery process simply because of the application of 1782. So more on that in terms of what it can do in terms of when you get to the hearings, and cross-examination will be the topic of my subject, but I thought I should comment on that.
Thank you very much, Dan. And we'll stay with you since you're our next speaker for this panel, and we'll learn more about how to conduct effective cross-examination in international arbitration proceedings that are seated in the US or the Americas, or that involve American parties. Go ahead, Dan.
Thanks, Sandra. And while I bring up my presentation, let me thank University of Miami School of Law. Let me thank MIAS and the JIDRC for inviting me to speak to you guys here today. Good morning, good afternoon, or good night. This is really, I think, really fantastic to be able to do this such a broad audience across the world. The first thing I would say, and by the way, I have very limited time. I'm your last speaker. That's maybe the good news. But I will say that the topic I have is a topic that I've spent over 30 years practicing, and I spent over a semester teaching at University of Miami School of Law. So we will try to cover very quickly just sort of an overview of the topic. I think you're going to have access to my slides that have some more detail that I may have to go over very quickly. But the first and fundamental thing I have to say is cross-examination in international arbitration is nothing to be scared about. It actually is a tool. It's a tool that is not to be considered as the determinative tool, but it's also a tool to be taken seriously because it's an important tool if used properly by the parties and by the tribunal. And as we'll see, it is a tool that is expected to be used in international arbitration. Quickly, I think what I'd like to go over is sort of the characteristics of cross-examination in international arbitration in the Americas. I'll talk a little bit about the strategies with regards to cross-examination, the challenges that you might face, the attempts to control witnesses and how to best do that. I will give you some tools also in preparing cross-examinations, and then finally close with 3 particular tools in that regard. In terms of the characteristics of international arbitration, you should know that, and let me change my view here because I don't have, okay. That's okay. It's a standard that's pretty much accepted in all of international arbitration. Now, how you actually use it will depend on the case. Arbitrators who are not common law lawyers, and as you heard from our panelists, in the Americas, we're going to have a very combined legal systems in the U.S. common law, but in Latin America, much more civil law, and the practices will vary greatly in terms of the application or utility of cross-examination. So you want to, even in international arbitration, where it's very much acceptable to do cross-examination, you're going to want to adjust it to your audience and know who your audience is. You want to make sure that it matches that audience so that it's not badly used or received by the tribunal. So what are some of the strategies in international arbitration? Again, know your audience, know who your arbitrators are, understand that they're not always going to be accepting of the practices of cross-examination. For example, I have had the experience of cross-examining witnesses in Latin American countries in court systems there, and the system very much relies on the actual judges or clerks of the court to conduct the examinations, much less the lawyers directly face-to-face to the witnesses. And so if you understand that, you understand that you're going to be much more reserved if you're doing a cross-examination in front of a tribunal that is a civil law tribunal than if you were doing it in front of a common law tribunal that might be used to a more confrontational type cross-examination that you'd see in a U.S. court, or you may have seen from some TV shows that try to portray what cross-examination looks like in the U.S. Tribunals will generally allow you a lot of freedom to cross-examination. So it's really up to the parties to sort of self-control how they apply it, how they do cross-examination. The lack of strict evidentiary rules means that anyone can decide in terms of what are going to be the applicable rules of how examinations are conducted. The institution rules give the tribunal full authority. So if you look at the IBA rules, for example, they will sort of set forth that the tribunal may limit or exclude any questions or allow questions. So it is, again, very self-guarded, self-executing in terms of how you're going to go about conducting a cross-examination in an arbitration. Now, one of the essential essence of what is considered cross-examination, and the difference when we think about what is direct examination versus cross-examination, direct examination is very open. It is very much an open-ended question format, which it would be for like the kind of a question that you see in the top of the screen here. Where were you on December 23rd? Now, a cross-examination question by definition is going to be much more leading. And in that regard, you see on the screen very much sort of the commandment of asking the question in a way that it's suggesting the answer. And that's a very extreme example of saying on December 23rd, same question, is it true that you shot Timmy McFarland in the face in the Northern Sacramento Whole Foods parking lot at 6:34 p.m.? Very specific, very controlled. That's obviously an extreme example, but it gives you the contrast about the open-ended question versus a cross-examination leading question that is usually the type seen. Now, the idea, the commandment of always asking leading questions comes from the notion that you don't want to ask a question in cross-examination that you don't know the answer to. You want to ask the witness questions that you know the answers generally, but there are exceptions to that. As we'll see, there are situations where an experienced cross-examiner will go beyond that sort of basic rule of only asking questions to which they know the answer to. Now, the next sort of conflict is how do you go about leading questions? Now, leading questions all have a certain element to them. So all of them will begin with this sort of terminology. It will be either, is it a fact that? Is it true that? You would agree with me. Isn't it true that? All of these are suggestive forms of asking questions. And then you go ahead and formulate the rest of your question, if it was a rainy day or not, but you're asking it in a leading way so that the witness already knows what answer you're suggesting to them in the question. There are three techniques that you want to think about in terms of the strategies for cross-examination. First of all, you're going to cross-examine someone for impeachment purposes. Now, what does that mean? It means that you're trying to send a message that the witness is not trustworthy for some reason. That doesn't mean necessarily that they're outright lying, but it may mean that the witness just doesn't have the appropriate knowledge, or the witness previously contradicted themselves in something they said in a letter or in a deposition. So you're impeaching the witness in some form, and in that way, you are lessening the value of the perceived truthfulness of that witness. The second technique is examining the witness just simply to get information. And this is where sometimes you might take a risk and you may ask witnesses questions that you don't actually know the answer to, simply because you want to elicit information from the witness. Typically, again, if you have depositions, you're going to do that ahead of time. You're not going to do it in the actual cross-examination in front of your tribunal. And finally, you're going to have cross-examining to limit the witness. This is what we call boxing the witness out. And on the screen, I don't have time to go through it, but you can see the kind of question that you would ask the witness is where you're trying to get the witness to confirm for you that their level of knowledge is such that allows in question what might be the real evidence in the case. And so you're boxing the witness out of something, or you're boxing the witness in terms of the cross-examination that you're asking. So what are the challenges with cross-examination? Well, the number one time limit, much like my time limit this afternoon with you all, is because most arbitrations are under chess clock. Each side is given an equal amount of time for the overall arbitration hearing, and you have to limit yourself. And I can't tell you how many times I've seen cross-examiners go too long with one particular witness and exhaust the time they had available to examine other witnesses. So time is a huge factor. Another factor is that the overall hearing has a limitation. The hearing may be set for a couple of days, a week, 2 weeks, and all of that has to be taken into account into the number of witnesses you're cross-examining and exactly what you want to elicit from those witnesses. The questions which the examiners may ask, again, the general commandment is to never ask a question that you don't know the answer to. And lack of depositions, though, and lack of having that kind of impeachment information sometimes is difficult, because in an arbitration, typically, the only thing you have in terms of being able to determine what is the answer to the question is the documents that are given in the case and perhaps some other information that may be provided in some other form, but you don't typically have the depositions, which goes back to if we had a 1782 action, if you have the ability to get testimony, you might then have the forms of U.S. discovery that allow you to do the kind of direct impeachment of a witness in that form if you had that. Other challenges that you have is questioning from the tribunal. In an arbitration, different than in other settings, the tribunal won't be shy to ask questions. And when they ask questions, you need to stop your cross-examination right away and allow them to complete their questions. And in that regard, it's important to listen and follow the questions that the tribunal is asking, because whatever the tribunal is asking is critically the most important thing. And your cross-examination has to adjust to that and try to then pick up on what the tribunal was asking. That many times then creates challenges of getting back to your own ideas, your own plan of what you were going to cross-examine on. Languages can also be a big challenge. Cross-examination has a certain rhythm to it. You ask questions, you get answers. You get more questions, you get more answers. You listen to those answers, you ask more questions. When you have translations in between, whether they're sequential or simultaneous translations, that will tend to break up that rhythm, and it will make it more difficult to have cross-examinations conducted. I have done, for example, cross-examinations with translations in Japanese. And again, the same issue applies whether it doesn't matter which language, you will find that there's a breakup of that rhythm that makes cross-examining much more difficult for the cross-examiner. It actually can be an advantage for the witness, because the witness gets to hear the question in their native language, in addition to if they speak any language of the hearing. If they speak the language of English, for example, they'll get to hear the question more than once. There are very narrow grounds for objection. So unlike what you see maybe in TV court proceedings, where you see a lot of objections happening to the questions by cross-examiners, arbitrators typically don't like that. You don't hear a lot of objection, and arbitrators will sort of shy away from that. They feel that they are capable of listening to the testimony, allowing the questions to be asked, answers to be given, and they will judge as to whether the witness is telling the truth and what's the value of the witness's testimony. So you don't see a lot of objecting. There is some objecting. If we had more time, I would go into the sort of style of that, but typically there's just less of it than you'd otherwise see. So controlling the witness, and I'll go through some of this very quickly. You're going to have witnesses sometimes that are volunteering too much information. So this is the witness where, notwithstanding that you follow my advice and you ask very direct questions, very leading questions, the witness still feels compelled to sort of answer a very broad question or add a lot more information to the question. And the technique there is to just stick to your questions, come back to your questions. So if the witness keeps trying to elaborate, try to come back to your original question and force the witness to sort of answer that question in particular and control the witness. Ultimately, if you have to, you can always ask the tribunal if the witness is going on and on. Tell the tribunal, would you please instruct the witness, Mr. Chairman, to answer my question and only my question that I'm asking. That said, though, don't worry so much about adverse testimony. I see lawyers who get very nervous because they follow the advice about leading questions, being very tight with their questions, but the witness still nonetheless blurs out some answer that you don't like. Don't try to cut off the witness. Don't try to appear like you're trying to stifle that witness. You're better off allowing it to happen. The fact that the witness goes on and advocates an answer may not look good for the witness in any event. And you trying to stop the witness from testifying just because they're not answering your question as tightly as you would like is not typically going to be well perceived by a tribunal. Preparing cross-examination, really quickly, the main issue here is prepare. Make sure that you've laid out what are your objectives for that cross-examination. What are you actually trying to look for? It's not going to be questioning the witness about everything they know about. Pick your topics carefully. Pick those areas in particular that are themes to your case and make sure that you know where to follow with the questions and how far to go with the witness. Sometimes how far you go to the witness, though, won't really occur. In fact, most of the time, until you're sitting there in front of the witness, because you're listening to what that witness says and you need to follow that and determine how far can I go. Sometimes with some witnesses, you realize I really don't want to go far at all. This witness is just going to be very combative. It's not going to be helpful. But other witnesses, you'll see that they actually can be helpful because they will fall into a cross-examination rhythm. Note-taking during examinations. Too often I see lawyers who are writing down notes feverishly, who are cross-examining. And the problem with that, of course, is if you're writing down notes while the witness is answering your questions, you're not doing the critical thing, which is listen. Most of your cross-examination should come from what you're hearing from the witness. You should have an outline. You should have objectives, as I said, but your actual questioning should adopt itself to what you actually hear from the witness. Feel out that witness and make sure that you start strong and finish strong. If you have a combative witness, don't let the witness end the cross-examination with a great long answer by them. Make sure you come back to a strong question to ask at the end that will close out the questioning in the format that you wanted it to be from the beginning, so you can show some control over that witness in terms of how you examine them. Finally, 3 quick tools. First of all, prior inconsistent statements. Like I said, one of the tools to use is showing that a witness has said one thing earlier and then later says something different. That puts and undermines the witness's credibility. Again, if you have a deposition, it's really easy, because if the witness was asked a question and earlier said that the light was green on a traffic accident case and later says that the light was red, you can contradict that witness between their deposition and what they then testify in the hearings. More difficult in arbitration with no depositions, but you could also do it with documents if a witness has said something in an email and then contradicts themselves at the hearing. Second, credibility attacks. Once again, this may be as a result of inconsistent statements. A lot of time it's to show bias of the witness. It's to show that the witness is not really being objective. Typically, witnesses in an international arbitration aren't outright lying, but they may demonstrate a certain bias to one side, and you can bring that out in cross-examination as to their general character and bias and interests. Finally, and this is the last thing I'm going to put on the screen, which is using what's the rules of probability. Now, this is probably the toughest part. This is where the experienced cross-examiner comes into play. This is where you ask questions where you really don't know the answer to. But if you see the sequence that I've got on the screen, it's where you ask Mr. Jones, I gather that immediately after the accident, you were upset. Now, you may not know the answer to that. He could say, well, no, I wasn't upset. But is that rational for that witness to say that right after the accident? So you take a gamble on that. If you take the gamble on that, you then ask the next question. If I heard you correctly, you were in pain at the time. Once again, if he just said that he was hurt, is he likely not to say he's in pain? If he says, he's going to likely again say he was in pain. And that then sets you up for the question you really wanted to get to, which is in such pain that you were not in condition to closely observe what everyone was doing in this accident or whatever occurred. So you're able to set up some very logical questions where you logically think through what are the likely scenarios of the answers they're going to give, and then finally set up the question where the witness now really can't sort of wiggle out of that. These are very quickly some of the sort of tools and ideas of cross-examination. I've put up on the screen there in my slides some authorities that you can also look at if you'd like to read more about the arts of cross-examination, which I think is a fascinating art in itself. Thank you very much.
Thank you so much, Dan. We'll now have some time to take some questions live that have been submitted through the Q&A function. Unfortunately, because of the limited amount of time that we have for our webinar, and we do need to move on to session 2 as well, we're only going to be able to take 2 questions live, but our panelists from session 1 will remain on the webinar and will be able to continue to answer questions in writing as we move forward. And I would like to start with question number 1 that was submitted by Rikia Sakamoto, asking, in the US, do you find that US practitioners or parties tend to dislike MedArb by the same neutral for international arbitration? And I'm going to go to Professor Rick Williamson on that one, who of course is an expert on any and all things ADR related. Rick, go ahead.
Yes, I can't speak to what practitioners and parties feel I'm fairly sure I've never seen a statistical analysis or a questionnaire on that subject. But I can speak to the question about what some of the problems and risks are. For those who are not familiar with it, MedArb is mediation followed by arbitration, and it can arise in one of 2 ways. You can actually have an agreement that says that that's how you're going to resolve your dispute, that a mediator will be appointed and that will be followed by arbitration if the mediation was not successful. If you have that kind of an agreement and you also specify that there's going to be a different person handling the mediation from the one handling the arbitration, doesn't seem to me to raise any particular problem. On the other hand, if the same person is going to handle both the mediation and the arbitration, and you might well want to do that to save money and time, that does definitely raise some problems, because mediation works best when the parties can speak confidentially to the mediator about things they don't want to share with the other side. And can a mediator be so disciplined as to ignore everything that was told to the mediator once that person is going to do the arbitration? And that does seem to be something which causes, in spite of the financial and time advantages, causes a lot of people not to go forward with a formal mediation arbitration agreement. It can also arise sort of spontaneously in the process of a mediation. The parties might say, look, you understand the situation now pretty well. Why don't you make a decision and will be binding on us? That's got some of the same problems associated with it. And one has to be quite careful. But at least in that circumstance, both of the parties now know that the mediator knows things that had not been shared with them, and they're comfortable with that and can let it go forward. Finally, it's worth noting that the opposite can be the case as well. That is to say, you're acting as an arbitrator, and the parties may then suddenly say, well, look, we're not so far apart. Can't you mediate this and help us to come to a decision? That, again, raises some of the same problems, because what if that doesn't work? Now has the arbitrator, the person now acting back again as arbitrator, learned things that they probably wouldn't have if it had just stayed in arbitration from the beginning.
Thank you, Rick. And we have time for one more question. I see there's a question on, let's see, we have another question on Section 1782 that says, as for Section 1782, which state would be proper if a Japanese company could use it before the ruling of the U.S. Supreme Court? So I think, in other words, the question is, where would you file your Section 1782 motion in the U.S.? I think, Matt, that question sounds like it's made for you.
Well, I'll actually answer that in a way that was recently dealt with by this case that I was talking about. And so, in fact, one of the underlying circuit courts and cases that Servotronics had brought, the lower court ordered the production to go ahead, despite the fact that there was a pending case before the Supreme Court. And then most recently, this is actually just this was just filed before the Supreme Court. Now, Rolls-Royce submitted a brief to the Supreme Court ordering that court to put a stay on that lower court's order to produce, because they said, look, this would be moot if the document production or the testimony goes ahead while you're deciding this and before you issue your statement. So if I understand the question correctly, if you're going to try to do it now and it's going to come to a head, you could do it. But I think that the outcome of the Supreme Court will happen before you would actually get any ruling on it. But if you were, you would need to see what kind of a situation you're in. If you're under a treaty, you're probably safe in any circuit. If you happen to be in a commercial arbitration involving companies and there is something that's relevant in a district court, you need to go to that court where the person or the company is located, and then satisfy the standards under the statute. The Supreme Court's not going to negate the usefulness of 1782. It is likely to either broaden it or keep it focused on those tribunals that are established under international treaties, international law, or foreign court proceedings.
Thank you so much, Matt. Unfortunately, we're running out of time for our Q&A session. So our panelists for session number 1 can continue to answer your questions in writing, but we do have to move on to session 2. I want to thank our wonderful distinguished speakers for the discussion that we've had. And we will be moving into session number 2 on legal education and practice opportunities in international arbitration. And I will be giving you an overview on legal education and practice opportunities in international arbitration for foreign trained lawyers in the United States. We will also hear from Takashi Yokoyama, who is a 2018 graduate of Miami Law's International Arbitration JD/LLM Joint Degree Program, and who now works as an associate with Tenzer Arieta in Miami. He will provide some reflections and impressions on his studies at Miami Law and his career path in IDR. And we would also like to welcome Professor Naoki Kanayama to this panel for session number 2. Professor Kanayama is a professor of law emeritus at Keio University Law School in Tokyo, where he taught courses on contract law, arbitration, and French law. Professor Kanayama will provide an opinion on legal education in the US and Japan, and also will provide a brief overview on the LLM program and global legal practice at Keio Law School. And for this second panel, I will start us off with a presentation on legal education and practice opportunities in international arbitration for foreign trained lawyers in the US. Okay, I hope everybody can see the slides. Here we go. So first of all, I wanted to provide you with a brief overview. Of course, there are a lot of institutions and organizations globally that offer lectures and training opportunities in international arbitration, and many of them have regular conferences and events in the US that focus on training and topics that are pertinent to this particular region. For example, we have the ICC Miami and New York conferences every year. The International Bar Association, the IBA, is going to have its annual conference in Miami coming next year. And also the International Council for Commercial Arbitration, also known as ICCA, had their annual congress right here in Miami a few years ago. There are also a number of lectures and workshops and trainings on international arbitration topics and skills that are offered by institutions and organizations that are based in the United States, or Florida in particular, but that have a global reach, so that they're accessible to practitioners and students and recent graduates around the globe. Some of these organizations are academic or arbitral institutions. And of course, we have Miami Law's International Arbitration Institute, also the American Arbitration Association, known as the AAA, and its international arm, the International Center for Dispute Resolution. JAMS, of course, JAMS Mediation, Arbitration, and ADR Services is a major arbitral institution located right here in the US, and also the International Institute for Conflict Prevention and Resolution, known as CPR. And then there are a number of professional organizations, of course, the Miami International Arbitration Society, which is one of the co-organizers of this event today. The Florida Bar International Law Section also has broad offerings, trainings, and lectures on international arbitration and dispute resolution. And of course, also the American Bar Association with its international law section. And especially right now, many of these institutions, many of these organizations have virtual offerings that are easily accessible from around the globe, maybe inconvenient in terms of time zones. It is after midnight here right now, but they are accessible, which is great, and which is really something that has increased in the past year. These events can be very helpful for general understanding of the local international arbitration framework, the local rules, any updates on specific cases, and so forth. Also, these events can be great to network with the local arbitration communities, but oftentimes these kind of standalone offerings, they don't, and they really can't provide like a comprehensive and in-depth education and training in the area of international arbitration and dispute resolution. And for that, many junior and mid-career lawyers turn towards a specialty LLM in the field, an LLM in international arbitration or dispute resolution. An LLM, for those of you who are not familiar, is a master's in law program or degree that lawyers pursue to expand their theoretical knowledge and practical skills in the area. Oftentimes, they choose a specific area, such as international arbitration, often also with the view of branching out and broadening their knowledge on a different legal system or different legal tradition, like US common law, for example. It also allows legal practitioners to gain valuable legal research, writing, and advocacy skills, and so forth, and for many, oftentimes in a foreign language, such as English. And last but not least, such a program, of course, allows you to build and expand your global network through the classmates that you meet, the professors, the alumni, and the legal community at large. And one such specialty LLM program in the field is, of course, our distinguished White & Case International Arbitration LLM here at Miami Law. We have a highly selective boutique program that brings together every year about 50 students from around the globe. It's a very, very diverse group. The program welcomes both recent graduates, both from the US, but also from abroad, who wish to specialize in the field, and also attracts more experienced, let's say mid-career US and foreign lawyers who are looking to redirect their careers or deepen their expertise in this field. So it's very diverse. And over the course of 9 months, if you're a full-time student, the students will engage in intensive study of both the theoretical, but also the practical aspects of international commercial and investment arbitration. And it is also possible to specialize on certain sectors or industries in our programs, such as maritime, sports, or art arbitration, because we do in fact have a number of different LLM programs that offer expertise in these fields. In the program, our students learn from some of the leading practitioners and academics in the field. Our distinguished faculty includes, for instance, Karen Lamb, who's a partner at White & Case in Washington, D.C. She's a Miami Law alumna and also the distinguished faculty chair of our LLM program. Meg Kinnear, who's the Secretary General of ICSID, which of course is the investment dispute settlement arm of the World Bank. Albert Jan Vandenberg, who is a well-renowned international arbitration expert and arbitrator. Of course, Dan Gonzalez, who spoke earlier on this very panel, here with us today. And also Jonathan Hamilton, who is a partner at White & Case in Washington, D.C., and the head of the Latin American arbitration group there. He also serves as the distinguished faculty chair of our institute. And in addition to these theoretical topics and course offerings, the students are also able to focus on the practical lawyering skills through advocacy courses, such as the one that Dan Gonzalez teaches, drafting, research, and so forth. And last but not least, the students have the ability to work alongside some of the practitioners in semester-long placements with the various arbitration practices in town and actually outside of Miami as well, through our International Arbitration LLM program. So what are some of the study options for LLM programs? And I'm talking specifically about our program, but these are really going to be very similar with many of the programs that you find, at least when it comes to the length and the admissions cycle. So an LLM program, usually when you do it full time, is 2 semesters or 9 months. There are part-time options, so that's a possibility. Usually LLM programs in the United States start in fall, which is August. We do allow for spring admission as well in January, which is a little bit more rare, and usually summer studies are not part of the program. Here at Miami Law, we have a very special program, a 2 or 2.5 year joint JD LLM and international arbitration, which allows you to earn both the grades, the specialized LLM and the JD, which is of course the basic American law degree, in as little as 2 to 2.5 years. No LSAT required, so that's of course a huge plus. And then for those students who are interested in first focusing and improving their legal English skills before embarking on their LLM studies, we also offer a 3-semester intensive legal English plus international arbitration LLM that usually starts in January. And then throughout the program, there are a number of options over the summer or also concurrently in the semester for individualized legal English support to our students as well. I included here a slide on the LLM application process. I'm not really going to be going over it in detail, but we will be sharing our material, so I did want to make sure to include that here. This is also very similar across law schools in the US. You will find many of the same requirements in terms of application requirements, the personal statement, resume, and so forth that you have to submit. And of course, if you're a non-native English speaker, also your English proficiency test score. Now, how can you practice in the United States as a foreign trained lawyer with or without an LLM? So when we come to this question, we have to first distinguish the authorization to work, because of course, many of the foreign trained lawyers in the program are here on a student visa. So I did want to mention that with the student visa comes a very important perk, and that is a 1-year work permit for foreign students called the optional practical training that starts immediately upon graduation. So it is very possible to remain in the US for another year and to really put all that knowledge and skills that you've gained during your LLM studies to work in a practical placement. Now, aside from these immigration questions, of course, there also is the question as to, are you authorized to practice law? So first of all, I did want to mention that without being admitted to any bar in the US, several states, and this is a state-by-state question, so the US is a federal country, and so different states have different rules on the matter of whether you're allowed to practice law. So this is something that has to be looked at from, by state-by-state basis. Now, several states, including Florida, have programs that allow foreign lawyers to practice as foreign legal consultants. The name varies from state to state, but basically the idea is that if you get vetted and properly admitted, you may consult on the law of your home jurisdiction only. So if you meet the requirements in Florida, it's 5 years of practice, full-time practice in your home jurisdiction, and you have to be at least, I believe it's 25 years old, then you can be admitted as a foreign legal consultant and you may advise on Japanese law only. So this is of course very limited, which means that many of our graduates decide to sit for the bar exam in the United States. And there are, luckily, about a dozen states that allow foreign trained lawyers to sit for the bar without holding the Juris Doctor, which is the basic American law degree. And one of these states is New York. Another very popular option is California. And so it is possible to sit for the bar exam in these jurisdictions based on the LLM only. And after being admitted to the bar in any of these jurisdictions, let's just say New York, for as an example, then of course you're able to practice law in New York because you're a New York admitted lawyer. But in addition to that, you're generally allowed to practice federal law in any other state in the country, and you also are generally allowed to work as in-house counsel. So those are some other avenues that open up. However, in order to become a fully qualified lawyer in the US, sit for any bar exam, including, for example, Florida, and about 30 other jurisdictions, you do need the JD, which is why Miami Law is offering this 2-year JD LLM joint degree program to make this option available to our students. Now, very briefly, let me just explain a little bit what the bar exam looks like. There's basically 3 parts to the bar exam in the US. The first part is the Multi-State Professional Responsibility Exam, which is also called the MPRE. This is basically professional ethics for lawyers. It's given 3 times a year in March, August, and November usually. And it is possible to take this part of the exam while you're still studying for your LLM. So many of our students decide to knock out this requirement while they're still students. And then a second part is the multi-state bar exam, also known as the MBE. And this really is the federal portion of the bar. This is given in all states except Louisiana, which is not a common law jurisdiction. It's given twice a year in February and July, and it focuses on the core common law topics: contract, civil procedure, con law, constitutional law, torts, property, evidence, and so forth. This is a 1-day exam, multiple choice questions, and immediately the day before or after the MBE, depending on the state, you will also be taking the state-specific portion of the bar exam. About 35 jurisdictions in the US administer the uniform bar exam, including New York and DC, but some states, such as Florida, have a state-specific exam. And it's given either the day before or after the MBE. So those 2 parts of the exam have to be taken after you graduate with your LLM, and they have to be taken together. Now, how do you apply for the New York bar? How do you apply to take the New York bar? So there are 2 categories really of foreign lawyers, and most foreign trained lawyers, including all foreign trained lawyers from civil law jurisdiction, have to go through, a rather lengthy evaluation of eligibility that is required for foreign trained lawyers, and that really should be started during the first semester of the LLM, so that you're sure that you can take the bar exam after you graduate. The second category is lawyers from core common law jurisdictions, such as the UK, Australia, the Bahamas, and certain parts of Canada, for example. And while they also have to go through this evaluation of eligibility, they do not have to meet any further course requirements. However, for civil trained lawyers who do need to meet certain course requirements, it is important to plan your LLM studies accordingly, because in addition to any of the specialty courses that you might be taking, your studies also have to meet certain requirements. You have to take courses on introduction to US law, legal writing, professional responsibility, and also at least 6 credits in topics that are tested on the bar. And those are some of the core topics that I already mentioned: business association, civil procedure, commercial law, and so forth. And then, of course, optional is any of the bar prep courses. We offer several here at Miami Law, exam workshops and study groups that can help you prepare. And then last but not least, don't forget to register. You register for the bar either in April or November each year. And so you have 1 month where this registration period opens, and that's when you need to register for the next administration. And we're running out of time. So of course, we're going to be sharing these slide materials. There are additional steps, believe it or not. After you pass the bar exam, you also have to get admitted. And that can take some time for foreign trained lawyers, but it looks more difficult than it is. And these are basically the requirements that just have to be addressed either during your LLM studies or immediately after, before you can become a member of the New York bar. And with that, I'm going to stop sharing my screen. And I am going to hand it over to one of our graduates, Takashi Yokoyama, who will tell us a little bit about his experience studying at Miami Law. Takashi completed both the JD and the LLM in international arbitration. So we'll hear from him now. Takashi, go ahead.
Sure. Thank you so much. Thank you so much, Sandra, taking the opportunity to remind me the classes, lectures, and today's panelists. Thank you so much. This is almost similar, so which is reminds my study at the University of Miami School of Law. I'm Takashi Yokoyama of JD and LLM graduate, international arbitration, and also associate at Tenza Arietta PLLC, Miami in Florida. Here, so I wanted to share why I chose the University of Miami among over 200 law schools in US. First, I wanted to obtain experience in some areas, expertise in some areas. I was interested in opportunities to manage it at the previous career. International arbitration in LLM was fascinating for me. Second, I thought 1 year study at the LLM program was not sufficient to obtain advocacy in English, and also to compete with other Japanese qualified attorneys in the market. I wanted to become more credentialized. I wanted to JD in addition to LLM. So 2.5 year study period was also reasonable for me at the time. Third, I need to have a good environment to study law in English. I knew there are many Japanese students at certain law schools in US, which might deprive me of opportunity to use English. There were no Japanese candidates except for me in Miami, which was a very good environment to improve my English proficiency. Fourth, I wanted to establish new connections that no Japanese practitioner has ever tried before. I have dreamed to become a pioneer to practice law in Florida and Latin America. Fifth, Spanish is a common language in Florida. I planned to study Spanish simultaneously during my study in University of Miami. Here, I wanted to share my experience at the university. I joined the International Moot Court program as a representative of the law school. At the program, I trained to practice pleading and argumentation before the tribunal. I obtained English advocacy and strong writing skills for submission documents in international arbitration. And also, I had 5 opportunities for practicum during study. In 2017 summer, I interned at the Energy Charter Secretariat in Brussels, Belgium, where I contributed to the initiatives discussing potential modernization of the Energy Charter Treaty. I have identified the investment provision to be reformed in consistency with current investment policy in international investment agreements. After graduation, I worked at WilmerHale in London. This was extremely rewarding experience that allowed me to work international commercial arbitration and investment arbitration. So I was fortunate to have an opportunity to observe the firm's partners' highest level of advocacy, which completely captivated the listeners to fill the cultural and linguistic gaps of unexpected potential users' understandings. At that moment, my goal was laid out to become an excellent advocate in this field. Now, I have just started to practice law as a new associate at the law firm. In the future, I would like to become an international corporate and litigation lawyer specializing in international arbitration, and I wish bridge the cultural and linguistic gaps for academia and business among Japan, US, and Latin America. Thank you so much, Sandra. I'll hand back to you.
Thank you so much, Takashi. And now we will briefly hear from our last speaker today, Professor Naoki Kanayama, who will provide an opinion on legal education in the US and Japan, and who will also provide a brief overview on the LLM program and global legal practice at Keio University. Professor Kanayama, please go ahead.
Thank you very much, Sandra. Well, in order to save the time, maybe I might skip the explanation about the program of Keio University Law School LLM program. All you need is to put the keyword Keio University LLM at Google search, and you will find easily the all necessary and important informations. So I just talk about a little bit about the history of the creation of our LLM program. It was created in 2017, April 2017, several years ago. And in order to cope with the legal problem involved by the globalization of the international businesses, still today, when Japanese big firms have a legal problem or litigation, they normally employ foreign lawyers, not many Japanese lawyers. And it is very bad for Japanese economy, first of all. So we need to develop the young lawyers capable of handling the international litigations, international arbitrations. And it was the Keio University LLM program was and is still the first serious LLM program entirely taught in English. And by creation of that program, we have already the students coming from 14 different countries, mainly from Asia. The top of the foreign students is, as you might easily imagine, the Chinese students. And we have a kind of luxury program, the courses. The courses offered are more than 70 subjects, 70. It's unbelievable. And the student body is right now 36. So the students are individually cared by the professors, and they can become easily friends each other. But under current situation of COVID-19, normally they don't come to Japan. All they do is to participate to the class via internet. So they miss this chance. But in that way, they can save money to stay in Tokyo. And let me talk about the tuition. I imagine that the Miami LLM program is a very, very nice one, maybe one of the best. But the tuition must be accordingly very high. But our law school, since it is located in Japan, traditionally the university tuitions is fixed in a low. So we currently charge $40,000 per year. So maybe for Asian students, it's not so cheap, but compared to the US LLM program, it's rather cheap. Needless to say that LLM degree here at Keio won't give students to take the US bar exam. That's for sure. But if they're qualified as lawyer in their domestic country, they can sit US bar in some states. So, and that can be students for introduction before going to the US to be trained at the US law firm or to go to the US LLM program in the future. And I'm teaching right now at LLM program a comparative contract law and the Japanese law in a cross-border context. The second one, I don't know what to teach still, but anyway, I'm enjoying teach there. And let me explain myself lastly. I studied in the US when I was really young for 2 years. at Knox College in Illinois. It's a small undergraduate college. But then I changed my mind to go to France, Université de Paris, the Paris University, for 3 years to study law there. And well, my knowledge is largely dominated by French law, continental law, but being located at Eden program, I started to study seriously the common law, contract law. So if there is an occasion, I'd like to invite one of you to come to as a guest speaker to KO Eden program. But sorry, we won't pay you your trip fees. Under the current condition, you will be invited via website. So please think about that. Thank you very much. That's all.
Thank you so much, Professor Kanayama. Unfortunately, we've now reached the end of our webinar. I do want to briefly address Professor Kanayama's concern regarding tuition. We do actually have a number of scholarships, including 2 full tuition scholarships. So there's always something that applicants can be considered for. It's been a great pleasure and an honor to be your moderator today, and I hope you will join us again next week for the second webinar in the series on Friday, April 30th. And I would now like to welcome back to the podium Adolfo Jimenez for some brief closing remarks. Adolfo?
Well, very briefly, thank you very much for joining us today, and thank you to the panelists for the really impressive job. It's really a whole lot of information packed in a short amount of time when you really think about it. The foundation of U.S. jurisprudence, dealing with competence, and separability, dealing with critical discovery tools, and then a really good overview of cross-examination, and then going into legal education in Japan. It really was a really comprehensive and jam-packed program, and I really appreciate everyone. Professor Kanayama, I am going to take you up on your offer, but I actually went on the website for Keio University, and I would love to go in person. I'll pay my own way. We'll have to wait till after COVID, but I look forward to it. Thank you very, very much, and best to everyone, and hope to see you soon on April 30th.